Hello, everyone, and welcome to our video on using judicial reviews in the context of housing. We are Francesca and Rowan from Law for Life, a legal education and information charity based in London. This video will provide a non-technical overview on judicial reviews for community groups, advisors, support workers, and in general for people without a legal training. We'll be talking about what is a judicial review, or in short, a JR, what kinds of issues, especially related to housing and homelessness, can be addressed through a JR, what the process entails, its remedies and outcomes, and in general, some pros and cons around using JRs in the context of housing. We will also talk about the role of community groups in building up JRs, for example, by filing complaints, gathering evidence, and so on. So today we have here with us our legal advisor, David Thomas.
I used to be a legal aid solicitor, and latterly I was specialising in housing law and also public law and human rights law insofar as it affected housing issues.
Thanks, David. So as Francesca said, this is a basic overview of the way that this particular legal remedy may be useful, even without a solicitor, in the general context of homelessness and temporary accommodation. In that respect, it builds on our training sessions on those subjects. Anyone who did not attend those sessions may find it useful to look at our preliminary video presentations on those subjects on our YouTube channel. This is a very technical area of the law, and to actually bring a judicial review in the High Court does require a solicitor in practice. However, there are still things which community workers can do and achieve themselves by collecting evidence for future cases and by the use of pre-action protocol letters, PAP letters for short. This video intends to give you a very basic understanding of how that might work, but we emphasize that you really need to have a working relationship with skilled lawyers, both to check your letter before it goes off and to take the case to court if the PAP does not work.
So David, what is a judicial review?
So judicial review is the name of a legal procedure. The more general name for this area of law is public law, and that name reflects its importance in the constitutional arrangements of the country. So keeping it simple, Parliament's job is to make the laws. Government, local authorities, many different sorts of public officers carry them out. Public law and the process of judicial review is the way that the courts make sure that the decisions which are made outside court are in agreement with the intentions of Parliament. So the example we're going to use today is it's up to a housing officer to decide whether to accept an application from somebody under the homelessness legislation. It's their decision, but they can't just decide it however they want. They have to make their decision within the law. If they don't, you can bring a judicial review of that decision. There are a lot of illusions about judicial review, mostly because the name sounds so exciting. It sounds as though a judge is going to fly in like a sort of judicial Superman, or maybe Judge Dredd, to look at a situation where there's injustice, to look at all the relevant information, and maybe talk to the right people, and then sort it out in some way. In fact, it's very technical and limited, rarely live witnesses. The whole thing is done on paper. The Judge Dredd scenario is more like a judicial inquiry, like the inquiry into the Grenfell fire or Bloody Sunday. They're pretty rare and they're set up by government, not civilians or lawyers. We're not talking about them. And another thing that judicial review is not is an appeal. Can't bring a judicial review just because you think the decision was wrong, that you don't agree with it. It has to be actually unlawful before judicial review applies.
That's an interesting distinction. What does unlawful mean in the context of judicial review?
So the basic idea is that the law gives a public officer, that is a government minister or local authority or a constable or just a housing officer, the power and often the duty to make a decision. So it's for them to make the decision, but the law also puts limits on the kinds of decisions they can make. They can't just do anything they want. So this is a really simplified version, of course. So I think of this in terms of the law imposing a boundary. So inside the circle here, inside the boundary, are all the possible decisions that our housing officer might make that are lawful. If they make a decision, any decision that is within that area, then it is lawful and judicial review doesn't apply. They've simply done their job. Even if you think the decision is wrong, it's not illegal. But of course, there are a number of ways in which they can trespass over the boundary, in which their decisions or actions can be illegal. So I'll keep to my housing officer example. The law says that housing officers must accept an application from a person if they have reason to believe that they may be homeless or threatened with homelessness. That's the test. First of all, as we said, the housing officer has to make a decision one way or another. So that's this one here. They're not permitted to do nothing at all. So the result is it may be unlawful if they fail to make a decision within a reasonable time. In this area of law, where the situation may be one of great need, it's up to the authority, the local authority, to have arrangements in place that allow an application to be heard and decided upon reasonably quickly and at least the same day.
So I heard of someone who went to a homelessness unit in their local council and they were given a number to be called, but when it was time to close the office, he had not been called yet, and he was then told to come back on the next day.
So that's a good example of a decision that's illegal because it wasn't made at all, because they had failed to put in place arrangements to allow them to take a decision in a reasonable time. So that's definitely unlawful. So secondly, the housing officer should take account of what is relevant. That is, whether the person might be homeless or might be threatened with homelessness, and anything that might help them make that specific decision. So they shouldn't take account of anything that's irrelevant to that decision at that moment.
We often hear of people being turned away because they have no local connection. Is that relevant?
That's a really good example of this. Local connection is a concept that becomes relevant and important later on in the process of making a homelessness application. But it has nothing to do with this decision that they are making at this point. So if a person is turned away, if they refuse to accept a homelessness application for that reason, it is illegal because they have taken into account something that's irrelevant. So third, the housing officer must act fairly. So for example, suppose the officer finds out something about the person. For example, the person applying has told the officer that they can't carry on living where they are because it's damp and overcrowded. So the officer rings up the landlord. And the landlord says they can stay as long as they like and the place is in perfect condition. This is relevant information that the local authority officer can take into account, but they must put it to the homelessness applicant to see what their comment is before they take it into account. Otherwise, it's unfair. So if someone's told the officer about something, they need to put it to the applicant for their comments before they take it into account.
And how about if the housing officer goes against what the local authority written procedures say?
That's another example of unfairness and an important one. So if the local authority has said in their homelessness strategy, say, that anyone applying will be permitted to have a friend or advocate with them for any interview, it wouldn't be fair for the housing officer not to allow that. So my fourth way in which you can take an unlawful decision is any public officer making any decision generally has to give reasons for that decision. The requirement to give reasons varies a lot from situation to situation. Most decisions in homelessness law have to be made in writing and have to give reasons, and they have to be sufficient for the applicant to understand why the decision is being made and to be able to decide whether or not they need to challenge it. So the decision whether or not to accept an application in the first place doesn't have to be made in writing. But if the homeless person asks, if it says, "Can I have that in writing, please?" and they refuse, and they say, "No, go away," that's probably unlawful. They probably can't do that. They need to give something in writing. So the fifth way of making unlawful decisions is this one. It's known to lawyers as Wednesbury unreasonableness. And it's a snare and a delusion. I haven't put unreasonableness there. People very often think you can judicially review a decision if it's unreasonable, but you can't. You have to, it has to be illegal. But there is a category of decisions that, as it says, are so bizarre that no one could possibly have reached them lawfully. It's where you can't put your finger on exactly what went wrong, but it can't, there must be something that went wrong because it is such a peculiar decision. It is really hard to persuade a court of this. It's probably the decision that the reason, unreasonableness, is probably the reason most often given in a judicial review application, that it very rarely succeeds. So, and that's why. So finally, there's the, I put in this thing, breaches the Human Rights Act or the Equality Act. These impose general obligations on all decision makers that they have to take into consideration. And they're therefore very likely to come up in judicial review, or judicial review might be a way to enforce them. They apply, of course, right the way across the law, and we're not going to try and summarize them here, as again, they are two more large, complicated areas.
Can you give us an example of how they might be relevant in this context?
Well, an example under the Equality Act might be if the local authority had made a general rule that homelessness applications could only be made in person and at a particular spot. And such a general rule would very likely be indirectly discriminatory against disabled people and is therefore likely to be illegal under the Equality Act.
So David, there must be hundreds of thousands of decisions made by public officers every day. How come there aren't more judicial reviews?
Well, there are a lot of barriers to bringing a judicial review that stop that from happening. So the first is, if there's any sort of appeal system from the decision, the High Court will expect you to go there rather than troubling them. So, for example, every time a traffic warden issues a ticket, they're making a decision that in theory could be challenged by judicial review. It has its legal and illegal sides, but there's an appeal system. And so as a result, the High Court would not accept a judicial review against that. By way of contrast, there is no appeal against a refusal to accept a homelessness application. And for that reason, actually, there's been quite a lot of applications for judicial review over that exact point, although not very many of them have gone all the way to trial, because normally the local authority gives in. Another reason that cuts down on judicial reviews is the High Court doesn't want its time wasted. So if there's a sensible alternative to judicial review, such as using the Ombudsman, they'll expect you to use that, or to give you a good reason, give them a good reason why you're not doing it. So, for example, that you need help really quickly, which the Ombudsman's not really set up for. Similarly, they're keen on people using mediation rather than going to court. And then again, also the High Court is very reluctant to hear a case that's just brought on principle. So you may say, this is wrong, I want to go and challenge this local authority policy or practice. But what the court wants is an actual person whose rights are being infringed before they will hear the case. And that can be a real problem when you're trying to use judicial review as a campaigner. And we'll talk about that in a moment. The procedure of judicial review is also set up to provide a filter to protect the court against unnecessary or weak claims.
So what is a procedure? How do you actually make a judicial review claim?
As with all court procedures these days, you're expected to follow a series of steps before you actually issue your claim in the court. This is known there's a pre-action protocol. And it's intended to make sure that both sides know the main shape of the dispute and that everyone has a chance to settle it before the court case starts. So judicial review is always supposed to be quick. The principle is they don't want you to be able to challenge decisions of public officers long after the event. So you have to bring your judicial review claim as soon as possible, or in any case within 3 months. As a result, the protocol itself is fast as well. So the first thing you do is send off this pre-action protocol letter. The other side has 14 days generally to reply. If they fail to reply within 14 days, you can start your case off in court on the 15th day.
14 days could be a long time in a homelessness case, or if someone is sleeping rough. So what if it's an emergency?
Of course, you're right. In some cases, you don't have 14 days. You need relief straight away. So often in homelessness law, your client is sleeping rough or will be within a day or two, and you can shorten the time periods if you need to. So when I was in practice as a solicitor, I have sent many protocol letters that gave the local authority only 24 hours or even 4 hours. If they fail to provide accommodation within that 4 hours, say, your next step is actually to go to the High Court and to look for interim relief, which is in practice an injunction to require the local authority to house someone at once. So this can be done really quickly, and it's certainly possible to get an injunction on the same day that your client comes to see you. The fastest way is you can simply ring the duty judge day or night to get an order. Of course, if you're expecting a court to hurry themselves to such an extent, you need to have a really good reason, or else the judge is liable to be annoyed. When you start your case, what you're actually applying for is permission to apply for judicial review. So that you can go ahead with your interim relief if it's really necessary, but you're applying for permission. There's a permission stage. And this is the final filter to protect the court from weak or unnecessary claims. The judge looks at the paperwork you've submitted and makes a decision on whether a full hearing is needed or whether the whole case should be dismissed. So if there's nothing requiring this to be done really quickly, this stage takes 3 or 4 months maybe. So you apply, you get your permission decision, then the other side gives a full response, and the full hearing, again, it depends on whether there's reasons for urgency. If there aren't any reasons for urgency, it could easily be a year or 2 before the initial application, before the judicial review is actually heard.
We sometimes hear of great judicial reviews that challenge the government or illegal practices, like the one that resulted in the Home Office deportations of EU citizens who were rough sleeping being declared illegal. What is the role of judicial review in the context of campaigning seeking policy level changes? So
very broadly, I guess you could say there are 2 kinds of judicial review. Though they overlap, this is just a distinction I'm making for the moment. But if a public authority is just doing something wrong and there's no other remedy, then it's simply a way of getting a remedy for an individual client. And the example we've been using would usually be that some housing officer has turned your client away for an illegal reason. You threaten the local authority with judicial review, and you actually trot off to court and get yourself an injunction so that your client is housed. But the second is where we're thinking as campaigners. If a local authority is doing something illegal on a regular basis as a policy, although it may not be a written one or an admitted one, a consistent practice, then you can do something about that, or you may be able to do something like that through judicial review. I'll give you an example. I found out through the experiences of an old client that the London Borough of Lambeth had an unlawful policy of diverting people who were applying as homeless into the private sector. So I brought a judicial review on behalf of my client. Lambeth, not wanting to fight it, just gave him a good flat. So I had no longer had a client who needed a remedy. So we had a go at persuading the High Court that it was an important point of public principle so that they would let us continue the case anyway. But as I've already said, the courts really don't like that kind of case, and they ruled against us. So this case illustrates two big problems with judicial reviews used for campaigning. The first is the judicial review route may not be suitable for you in the first place, because as campaigners, what we campaign for is justice, social justice. The law may not, the law may be on our side, but it may not. So in this particular case, the law was changed shortly afterwards under the Homelessness Reduction Act. It was okay. It's okay for for local authorities to divert people into the private sector. If you think that's a wrong thing to do, you would be able to campaign against it, but only politically. Law will be no use to you. So that's the first thing I want to say. Your particular issue may not be suitable for a legal route for that reason. And the second problem with judicial review is local authorities will avoid a final hearing. If you actually have got them caught out using an illegal practice and they want to go on using it, then they will just give in. And if they give in, you've got no final judgment, you've got no precedent, you won't be able to stop them using the process. So it might have been possible to do better in the case that I brought. If we had a number of cases where the same problem had arisen that we could have run together, it would have been more difficult for the local authority to concede, and it would have been easier to argue to the High Court that this was an important point of public principle. So that's the sort of thing, we tried to do that, but as solicitors, we have fairly limited number of cases coming to us. So campaigning organisations, grassroots organisations may be able to really help on that. So they can bring together numbers of people with the same problem. Another really important way that grassroots organisations can help is by investigating them. So public authorities tend not to be open about practices they follow that may not be legal. Rowan gave us an example of the EU rough sleepers case. It was a grassroots organisation, North East London Migrant Action, who chased this issue through loads of individual cases, and lots of documents and freedom of information requests, until they managed to pin down the Home Office and the voluntary sector organisations helping them, and had the evidence that the lawyers could then use to take to court.
So given these possible problems with judicial reviews, are there other ways to approach these issues?
Well, when you have public officers using an illegal practice like this, the other main option to tackle it, apart from the political route, is through ombudsman. Ombudsman can be really unsatisfactory. You have to work your way through the public offices, public body's complaints procedure before they'll take the case. And in my experience, they tend not to take a very firm line on legal issues. They're a bit kind of squashy, and they're mean with compensation. But on the other hand, they're free. You don't need a tame lawyer. And they do have the power to require local authorities, for example, to change their procedures and to give their staff training if they're convinced that there's something that's systemically unlawful about it. And the High Court can't do that. So in that way, they can be really useful.
So apart from these campaigning strategies, how can community organisations use judicial review?
So the most important thing, if you're thinking of using judicial review for what you're doing, is to have good relations with a decent solicitor who will bring the eventual case for you. but this is these are things we've covered already, but they're really important. In addition, you're the people on the ground. You're the ones who can pick up the recurring patterns of problems that people face and which seem to be unlawful. And when you've noticed such a pattern, you can collect the evidence and document them. You can do investigation. You can gather the evidence to demonstrate the unlawful practice. So it may be possible for you to do the first step of a judicial review together and to write a PAP letter, as we call it. That's the pre-action protocol letter to the public authority in order to force them to obey the law. So, as I've already said, you need a solicitor in the background to escalate things if the letter doesn't work. But in some sorts of situations, you may be able to send the letter, get the results you need without their being involved, other than to check that the letter is okay. And by means of doing this in repeated ways, to help build up a case to challenge the practice. There's an excellent and innovative project being run by DPG solicitors that provides a really good example of how this sort of thing can work. So, under this project, organisations can sign up for the scheme. That's the scheme. The workers who will be writing the letters take an e-learning course to give them some background in the law and in judicial review procedure. The project provides PAP template letters relating to many suitable situations for using this tactic, mainly in refugee law, but including some for homelessness, where the worker fills out the details of the letter from their knowledge of the case, and then, very importantly, the letter is checked by a solicitor before it goes out. So, in practice, the vast majority of these letters result in the local authority giving way. Where they do not, the project puts the worker in contact. The project will put the worker in contact with the firm's solicitors, who will start judicial review proceedings in the High Court for them.
Can you give us an example of a case where that might be useful?
So, in this project, there needs to be time to send a PAP letter and for the local authority to have time to respond. So, the example we've been using of a housing officer refusing even to accept an application would not usually be suitable, because usually you'd want to be able to send it to a solicitor straight away because the situation will be really urgent. But in less urgent situations that keep coming up, that's when this kind of PAP letter might be most useful. So suppose your local authority uses privately owned hostels with shared accommodation to put up families. They're not supposed to do that unless they can't find anywhere else, as it's recognised to be a bad environment for children. And there's a firm legal rule. This is the rule against B&Bs. There's a firm legal rule that even if they do have to put people up in this kind of accommodation, it must not be for more than 6 weeks. So if that's happening a lot in your local authority, the PAP project supplies a precedent for a PAP letter of this kind, and serving the PAP letter is very likely to result in your client immediately being moved somewhere more suitable. If it doesn't, then it's a straightforward judicial review for the solicitor.
And is joining the PAP project the only way of doing this?
Absolutely not. It's a brilliant example of what can be done in this sort of way. But if you already have, or if you can form a good relationship with the local firm of solicitors, then approach them and see if they'd be interested in supporting you serving PAP letters by providing you with precedents and checking your letters. It's really worth their while. So, for example, there's a really good housing activist organisation called Hassle in Lambeth and Southwark in South London. And they work really closely with Public Interest Law Centre. So they can use, and probably do use, I don't know, PAP letters, and then they'll have Public Interest Law Centre to back them up when they need to.
Thanks, David, for this really useful information on judicial reviews. And thank you, everyone, for watching this video. Below the video, you will find the links to the resources, the web pages we have mentioned, as well as the links to our other videos that explain more about the law, and make sure to check them out. Thank you.
Thank you.